Lordship, I beg to mention a criminal petition number 752 of 2024. Lordship, this matter was last listed on 24/6/2024. It's been almost 1 year, Lordship.
723.
Yes, 752 of 2024, Your Honor. So, Your Honor, matter may be listed on 10th of June.
It will be listed. We'll see the date. We'll give them.
Okay.
Yes.
I beg to mention item number 2. Your Lordship, engaged counsel is out of station, Your Lordship. The matter may be passed over for the day.
Yes.
May I please, Your Lordship? Lordship, I beg to mention for listing one anticipatory bill that was filed on yesterday, Lordship. It may be listed on Monday, Lordship. There is some urgency in this matter because
Tuesday.
is highly obliged.
May I please, Your Lordship? I beg to mention the listing of a criminal revision petition, Lordship, relating to Jilna Supari.
Before this court, revision petition. No, revision petition. Only criminal petition, not the. Okay.
Yes, Lordship. The arguing council will confirm the Delhi, Lordship. So the matter may be taken up of either 19th of June or 20th of June.
You make a mention in Monday. Why you mention it now, today? About 2 weeks ahead. So make a mention Monday next. Okay.
Not of Lordship.
May I please, Your Lordship? I pray for listing of criminal revision petition, Your Lordship. Lordship, the matter is last listed on 18/2/2025. Next
18th of?
week, 18/2/2025, last listed on 18/2/2025.
Okay.
Next week, can you be?
12th.
Okay, sir.
May I please, Your Lordship? Lordship, I beg to mention for listing of an IA criminal, Lordship. Next week, immediate, Lordship.
12th.
Like this.
I'm trying to mention a criminal petition which was last listed on 26/11/24. Any date, Lordship? Next week or after that, Lordship? Any date, Lordship?
11th.
Mention. May I please, Your Lordship? I beg to mention item number 4, my lord. Can this matter be taken after a week, my lord? Criminal appeal, my lord. Everything has been received. Paperwork has been received, my lord. We need some time.
Look, we'll have it.
4. That matter, my lord, on that deal also I would draw. This matter due to non-pleasure of earlier rejection in my pleadings. By that you also by order that 28 by my lord. It is only on the basic, my lord, primarily on the one ground, the
In the earlier case, did we call for the records?
yes, my lord, the records, my lord.
Records are available.
The scan copy was called for, my lord. I don't know, the yellow was already disposed on 28. The scan copy was called for, my lord.
What was the number?
Last, no, last, my lord. 1427/2025. 14 BA 1427.
One four two eight.
27, my lord. 1427/2025.
List on ninth along with the records of bill application number 1427/2025
File updated on 10, my lord.
on tenth, okay, for your account. On tenth. 1427/2025. Disposed of on 13/05/2025. Okay. If the records are there, it is okay, otherwise
So
we'll.
it's going to come on that day, it's going to be received. my lord.
Should have been, let us see.
Yes, my lord.
Let us put it and some.
Yes, my pleasure, Lordship. The 483 benefit application, Lordship. The FAR Lordship, final page. The open file by the customer authority, Lordship. The allegation is that Lordship, that some foreign tickets were recovered from the vehicle of the presentation, Lordship. His vehicle was seized along with the said foreign cigarette, Lordship. Now he is more than 30 days in custody, Lordship.
AB,
No,
No,
PL, Lordship.
item
I think-
number.
I don't know, but
to whom?
earlier AB was there, that was rejected, therefore we file application.
Issue actual loss, no rejected, I have another said order loss at page 16 losses. This honorable court has directed me to appear before the customer authority losses, accordingly he appeared losses. The customer authority again told him that he should appear on when the next summon will be issued. And accordingly, next summon was issued losses, he appeared, he cooperating with the investigation losses. Page number 16 alone. Can you see? Sixty days the mandatory pure losses.
When
Okay.
arrested when?
That's around 6/5. Let me kindly see the page 13, paragraph 70 of the petition filed by the customer authority lordships. She was arrested on 6/5/2025. 17 number paragraph. Lordship. Page number 13.
Take it on. Yes.
Subsequent business not happened on 22nd of November 24. One truck loaded with the foreign made cigarette was discovered at one petrol pump in abandoned condition. On inquiry, it was found that the present petitioner is the owner of the truck and with his consent, all these things were done. Thereafter, number of summons were issued, but it didn't appear. And he approached this honorable court and this honorable court violated that requisition to appear before the authority. And on the inquiry, it was found that his involvement was found. Now, Lordship, the investigation is going on. And he has failed to disclose the name of the person who has took the truck. So all these things are under investigation now. But he admitted that with his consent, the cigarette were loaded in the truck. And all the provision of law has been complied with while arresting the person. The case that is submitted before the Lordship for continuing. Can I take it? Can you take it? The distinct Lordship, we treat from the spot when the team intercepted the truck. We parked the truck in a petrol pump and fled from there.
Heard Mr. T. Suchia, counsel appearing for the petition. And Mr. S. Pending counsel. Custom Department. For the full respondent. Petitioner namely Sussex as well as application. In Sussex State 2705. praying for his bail in customs case number such and such, under section such and such, in which he was arrested on 06/052 2025 and is in custody since then. The case of the prosecution is that on receipt of specific information by the anti-smuggling unit, Guwahati Customs Division on 21/11/2024. Authorized personnel from said Customs Department Division proceeded towards Roha proceeded towards Nagaon and found the said truck bearing registration number AS03CC5407 parked inside the Bharat Petroleum Fuel Station at the National Highway number 127 within bracket Arswal and NH37 at Ahotguri district Morigaon under Nelly Police Station. Station ट्रक लिखी सा ट्रक लिखी भी Ashok Leyland CA1815 FBL 47BS6 truck bearing registration numbers. However, it was found that the said truck was abandoned by its driver. Later, in presence of the independent witnesses, personnel from the Customs Department, Guwahati Division, recovered 9,80,000 sticks of foreign origin cigarettes valued at rupees 2,53,00,000. In 50 separate boxes. Bracket folding. 48 boxes containing 2 cartons each. And 2 boxes containing 1 carton each. Later, the said truck along with the seized foreign cigarettes were brought to Guwahati Customs Division at Guwahati. During investigation, police found, the personnel from the Customs Department, Guwahati Division found that it is the petitioner who was driving the said truck bearing registration number and park it inside said Bharat Petroleum Fuel Station at Ahotguri, district Morigaon, in the national number 6 and 6. And accordingly, He was taken into custody on 06052025. Prior to his taking into custody, petitioner was given notice but he did not appear before the concerned investigating officer of the anti-smuggling unit of Customs Division, Guwahati. Next. From the case records in original place before the court by Mr. Carroll and its standing counsel, Customs Division. It is seen that the investigation is at the nascent stage. And there are sufficient incriminating materials against the petitioner with regard to his involvement in the alleged crime. It is also seen that the petitioner is not fully cooperating with the investigation of the case. And did not disclose the origin from which he had procured those foreign cigarettes. Considering such materials,
Lordship,
the case
she is cooperating with the investigation, Lordship. When the first notice was issued, Lordship, he approached this honorable court, Lordship. This honorable court is directed to appeal for the custom authority, and accordingly he appeared, Lordship. And
Data sentence. It is to be noted herein that on receipt of summons from the anti-smuggling unit of Customs Division, Guwahati, he approached this court by preferring an anticipatory bail application. However, the court by order to the 27-03-2025 passed in AB number 660/2025. After considering the case record, rejected such PRS bail application of petitioner, directing him to appear before the Superintendent within bracket Anti-Smuggling Customs Division, Guwahati.
on 29th he appeared, Lordship.
He appeared before the Customs Authority. Remarkably, stands rejected.
Much. In this case, else,
Considering this, the defense of the petition sentences can be considered for this. That's what it is. For instance,
yes. So in this case, the petitioner approached this honorable court second time. His main contention is that mandatory provision has not been complied with. And yesterday appeared.
no representation on behalf of the petitioner in court. But Mr. S.C.K. Standing Counsel NCB.
No,
Customs or NCB?
custom law.
Customs. 15-4. Equal.
Lordship,
Yes.
Lordship, application 483, Lordship.
Hmm?
483, Lordship, application BNSS. So allegation 120B 302, Lordship. So behind the bar since last 95 days, Lordship.
Only 95 days.
Yes, Lordship. 95 days. So Lordship, the initiative, Lordship, in the affair, arms act was there, Lordship. They say the petitioner number 1 who has committed the shoot to the 15%. But subsequently, the concerned police investigate, the arms act was withdrawn, Lordship. in the charge sheet. And the charge sheet is a page 20 lordship. So the informant was make out some exaggeration in this regard lordship, the affair, some projected lordship. So here the petitioners are not involved in this regard lordship. So the petition number one is a teacher lordship, subject teacher. And he was appointed in the year of 1993 lordship. Since that's more than the 25 years as a professor lordship. So their teachers, subject teachers, cannot commit such of the offense lordship. So lordship, since last 95 days behind the bar lordship, I have found two husband lordship. The Supreme Court
Oh,
lordship.
that the old case 2012 or something like that.
Yes, lordship. FIR lordship in the year 2012 lordship.
That
So lordship, as per the direction of this court lordship,
there was an interference by the court. Court did not grant you any bail, but you somehow managed. Okay, that's the matter.
so lordship, with due respect lordship, in response added by this honorable court lordship, so therefore I have surrendered lordship. Surrender on lordship 4/3/2025 lordship. Just kindly find out page 42
Just
lordship.
a minute. What is your name?
Is a petition number one is a Moinul Haq, and the second petitioner is the Idris Ali lordship. Moinul Haq is it about 57 years, and the second petitioner is a 76 lordship. What is the Supreme Court held lordship, the two judgment lordship, I have lordship, and the line lordship. Regarding this prolonged lordship, the trial lordship on that way is a violation of the Article 21 lordship. Thank you to the plan. If a Sheikh Javed Iqbal lordship. Last one lordship. And another is the Athar Parvez lordship. Yeah, violation of the Article 21 lordship of the Constitution lordship. It's a simple paragraph lordship. Very simple paragraph. The Sheikh Javed Iqbal is the latest judgment lordship, 2024 Supreme Court held lordship. Okay. As for the charge sheet, there is this 6 number accused lordship. So the other accused are absconding on that lordship. The prosecution has tailored in this regard lordship. They have duty bound to spirit trial lordship. So, this 2012 matter lordship. So now, as per direction of this honorable court lordship, I have surrendered before the court lordship. So trial has not been started. Even though lordship 95 is behind the power lordship. So the Supreme Court held lordship is a para number 23 lordship. So,
Yes, what is the claim? Because it was
Lordship,
Arms Act, it was not, now it is not under the Arms Act.
Yes.
That's the
Lordship,
reason.
Yes, Lordship, so Your Lordship, prolonged trial Lordship on the latest judgment of the Supreme Court Lordship. So yeah, Javed Iqbal Lordship and 2024. Honorable Apex Court Clear defined Lordship, para number 23.1 Lordship, page number 13 Lordship. Yes, very small paragraph Lordship. 23.1 Lordship. So here Lordship Clear defined Lordship made it Lordship. If the state or any prosecuting agency, including the court concerned,
Okay.
has no provide to protect
Heard Mr. Rasidas, counsel appearing for the petitioners. And Mr. B. Sharma, additional public prosecutor. Mr. Sharma, you have to say something?
Lordship, this is a heinous offense, Lordship, and there is no question of prolonged incarceration now, Lordship, only 90 days for custody, and Lordship, his conduct has to be seen, Lordship. He did not appear, there was a specific direction for him to appear before the learned court on after 30 days, Lordship. He did not comply with that, Lordship. And as
I
regards the petitioner number 2 is concerned, Lordship, his claim is totally silent in this petition, Lordship. And petition number 2 was shown as an absconder in the charge sheet, Lordship. There is no mention as to why he did not participate in the proceeding, Lordship. So in that regard, Lordship,
That it has reflected lordship. Before the police concern, I appeared.
Petitioners namely such and such and such. Address common people noun to be eligible. Petition number 1. The son of petition number 2. It is stated that the petition number 1 is a teacher by profession. Where is the records of the PRC case numbers assessment that was followed? As per the FIR, dated 18/03/2012. Lost by one Mosammed Banisha Khatun,
Yes, sir.
before the Hoiburgaon police station. Hoiburgaon police outpost. The case is that the previous night around 12, when our son Muhammad Safiqul Islam was sleeping in the house of one Rehana Khatun of Simuliguri, along with his wife and 3 sons and daughters, and herself. The petition number 1 and petition number 2 called him outside and when he went out, the petition number 1 and petition number 2 took him under the light and along with the other accused persons surrounded him and killed him, attacking him with the sword, dagger, and also, and further, the petition number 1 shot at him. As the said informant along with the other family members made hue and cry, the petition number 1 made shot the offender and threatened him. Said affair was initially registered as Hoiburgaon traffic outpost GD entry number 525 dated 18/03/2022 and on being forwarded to the Nagaon Police Station. It was registered as Nagaon Police Station case number 374/2012 under section 120 within bracket B oblique 302 IPC. Related with section 27 of the Arms Act. It is submitted that after completion of the investigation, police investigation, Sarsit Police Network, Sarsit in say Nagaon, Sadar, PS case number 374/2012 was submitted on 31/12/2023. By charge sheet number 1073 under section 120 in bracket capital B oblique 302 IPC. Showing the petition number 2 and against the petition number 1, charge sheet petition, and the petition number 2, showing the petition number 2 and four others as absconders. It is submitted by the petitioner. Though initially the case was registered under section 27 of the Arms Act. But as during investigation,
Not to think that, Lordship. I'm sorry for that, Lordship.
Hmm?
Just only one point, Lordship. So here the Supreme Court had, Lordship. So the whatever the inherent activities or serious offense, Lordship, the prosecuting agency cannot be opposed in regarding this case, Lordship. The para number 23.1, Lordship, Supreme Court had, Lordship. That is judgment, Lordship. Honorable Justice Ujjwal Vyas has the order, Lordship. Para number 23.1, Lordship. Case number 13, Lordship.
Okay, we'll consider.
Yes, Lordship. Master, Lordship.
But after completion of the investigation, the search sheet against them and the other accused persons that case were submitted under section 120 within bracket B oblique 302 IPC. Mr. Das, learned counsel appearing for the petitioners relied on a decision of the Honorable Supreme Court in the case of Sheikh Javed Iqbal, alias Asfaq Ansari, alias Javed Ansari versus State of Uttar Pradesh. in criminal appeal number 2790/2024, decided on 1807/2024. I have laid down that 23.1 vote করে দিব। 23 হলো, অকল 19 এটা আছে। I have laid down that অকল 19 vote. Yes, and which other paragraphs you want to rely?
Another paragraph lordship, 32 lordship. 23.1 and 32 lordship.
As the petitioners are in custody for since their arrest on when they were arrested, Mr. Das. When they were arrested,
4325.
4325.
I've surrendered before the PGM lordship. 4328. Annexure 5 lordship. Page 42 lordship.
Page,
Page lordship, 42 lordship. Annexure 5 lordship.
would the petitioners,
Yes, lordship. Yes, lordship. 42 lordship. Yes, PGM plus the order lordship.
surrendered before the court of learned sub judicial magistrate. No. On 04032025. No. They should be considered for failure. On the ground that they are entitled for speedy trial and that the trial of the case have not yet commenced, though charge sheet in the case was filed on such and such date. Incident occurred on the intervening night of 17/03/2012 and 18/03/2012. Son of the informant expired due to physical assault on him by the sword and other sharp weapons and on being hacked by the accused person's case. On his head, shoulder, neck, and back. Postmortem report of the deceased. Dated 18/3/12 indicates that the date of the disease was caused due to shock and hemorrhage as a result of head injury and the other injuries described in the said PM report. Petition number 1 claimed that he is a teacher. It is seen that the petitioner earlier approached this court immediately after the incident. Where is the earlier order of the court?
Lordship, RP is 37, Lordship.
The first order of Justice Musar.
Oh, 6. Yes, 36. Case number 152. Yeah. No, and the Lordship judgment.
In AB number 1523/2012. Praying for his prayers bill and said Nagaon PS case number 374/2012. The court in advance on perusal of the case diary clearly observed that said AB number 1523/2012 preferred by the petitioner, number 1, is not a fit case for granting privilege of pre-arrest bail to him, and accordingly it was rejected. However, on the prayer of the petitioner 1, the court in advance granted 30 days time to him to surrender before the learned Chief Judicial Magistrate Nagaon in the said Nagaon PS case number 374/2012, registered under section 120, such and such. But the further observation that on his surrender, on the surrender of the petition number 1, he may make appropriate application for bail before the learned CJM Nagaon, and the same may be considered and disposed of in accordance with law. During by order dated order dated 16/5/2012. During the said period of 30 days from 16/5/2012, it was specified in said AB number 1523/2012 that in the event of arrest of the petition number 1 in connection with said Nagaon PS case number such and such and such, he shall be enlarged on bail on furnishing a bail bond of ₹30,000 with 1 local surety of the like amount to the satisfaction of the arresting authority. After filing of the search sheet in said Nagaon PS case number such and such, on 31/12/2023, the petitioner preferred another pre-arrest bail application in said Nagaon PS case number such and such, being AB 3312/2012, 2024. This court, finding that the petitioner was directed to appear within 30 days from 16/5/2012 before the license is in Nagaon, in said Nagaon PS case number such and such, and to surrender before the said court. And then to approach the said court for bail. But the petition number 1 did not comply with the said order. Rather, obtained bail appearing before the concerned investigating officer of such and such. Since the order of the court dated 16/05/2012 passed in AB number 1523/2012, this court, by order dated 06/01/2025, rejected the pre-arrest bail application of the petitioner in Nagaon PS case number 374/2012, which has already registered as PRC case number 817/2024. After filing of the search sheet in said case on such and such, directing the petitioner, number 1, to appear before the concerned Learned Chief Judicial Magistrate Nagaon in said PRC case number such and such, arising out of Nagaon PS case number such and such. Pursuant to the same, the petitioner, along with his father, petition number 2, was absconding since the date of the incident and evaded arrest or appearance before the concerned investigating officer of said Nagaon during the entire period. Together appeared before the London Chief Judicial Magistrate on 04/03/2025. And surrendered before the said court. However, their prayer for bail in said such and such PRC case number such and such, on perusal of the case records, the learned CJM rejected. From the order of the learned CJM Nagaon, passed in said PRC case number such and such on 04/03/2025, it can be seen that the other accused persons of the case still did not appear before the learned CJM in said PRC case number such and such, arising out of November such and such, under section such and such. It is only on appearance of such and such the learned CJM Nagaon is likely to commit the case to the Court of Learned Session Judge Nagaon for its adjudication as section 302 IPC is triable by the Court of Sessions till the other accused persons of the case named in the search sheet against the other accused person said is not filed. On perusal of the records of the case, it is seen that No fresh summons have been issued to the other accused persons in the case. They are yet to return. Considering the surrender of the petitioners pursuant to the order of the court dated, we have order to be and subsequent order to be. And they be in custody since 4/3/2025. It cannot be said that there is an inordinate delay on the part of the petitioners. Violating the right of the petitioners under Article 221 of the Constitution of India for such speedy trial. According to this bail application of the petitioners in PRC case number such and such, considering their detentions in such and such, stands rejected.
Lordship, is as well, Supreme Court held Lordship, the terms and condition is Lordship, if the prolonged trial Lordship, on that way Lordship. So, there are number
Mr.
34.
Das, we must consider it from 4/3/2022, trial has not been. Ask the other accused persons who are your close friends to appear, then we'll consider. Yes, next.
Massively.
Yes, Mr. Boardman, what's the matter about?
My lord, only for the bailer, my lord, lordship has granted the bail with two conditions, my lord. That your lordship will see at page, my lord, 11, my lord, para 30. 2 lakh each local, my lord. One government employee from the state of Assam. That is, my lord, one.
What is the guarantee that you will appear? Who will give that guarantee? Once you will go for Manipur?
No, my lord, I'm from Meghalaya, Shillong, my lord.
Once you go for Meghalaya, who will give you the
My lord,
guarantee?
his own brother is a government employee of Meghalaya, my lord. He will stand, my lord.
That is the reason we have considered. And that is why we have said that who will give you that security that you will appear during
My
the
lord,
trial? of the
any
case?
other, my lord,
You tell us, Mr.
one
Boardman.
local surety, my lord,
Local surety won't do.
one local surety and his,
That is why we are saying the local surety vanishes. The
my
local
lord, his
surety
own
vanishes.
brother, my lord. Own brother is a government employee of Meghalaya, my lord.
How many services he has?
My lord,
How many services, how many years of services he has?
many years, my lord, many years, 10, 15 years, my lord. Sir, I cut to us, na?
Meghalaya, there will be no jurisdiction of this court.
My lord, lordship can make my submission, my lord. I have photocopy his I-card also. Lordship, kindly have a look, my lord. Date of birth, na? Okay.
See, Mr. Boardman, now this is what we have passed this order, not only in your case, in many other cases. The reason is simple because you are from a different state. Even if the notice are issued to the bailer,
My lord.
if the petitioner doesn't appear during the trial, this
My lord,
court will have no jurisdiction.
his own brother, my lord. At least, my lord, lordship,
Otherwise, see, Mr., we have considered entire aspect, we have granted you all the benefits. But at the same time, the court is also have to think about what will happen with the trial if you do not appear. Some
lord,
kind
he
of
will-
assurance, that assurance should be reliable.
his
and
brother
efficient.
will stand as a bailer, my lord. I have given his I-card, my lord.
Possible.
His own brother, my lord, blood relation brother, working in Meghalaya State Electricity Board as a accounts officer or accountant, my. Only that much, my lord, lordship consider.
Heard Mr. Jay Borvina, counsel appearing for the applicant. And Mr. B. Sharma, learned additional public prosecutor appearing for the state opposite party, sole opposite party.
Other two cases also, my lord.
The applicant is from the neighboring state of Meghalaya. He was arrested on 10/02/2023 in connection with Gorsuk Police Station case number 35/2023, corresponding to GR number 1078/2023. Under sections 21 within bracket C/29 of the NDPS Act. As 237 grams of heroin was recovered from the possession of the petitioner.
Not exactly from the petitioner.
The conscious possession of the petitioner. FSL report dated 08/05/2023. Confirmed the said substance recovered from the conscious possession of Peter to be heroin with the presence of 84.28% of with 84 millions, and the other powdery substance that was recovered from him to be methamphetamine. Trial of said Gorsuk PS case number 935/2023, corresponding to GR number such and such 107/2013. Being NDPS case number 85/2023 is going on before the Court of Learned Special Judge, NDPS, the Kamrup Metro Guwahati. On his application for bail, being bail application number 1681/2025. This court, by order dated 29/05/2025, passed in bail application number 1681/2025. Granted bail to the applicant due to non-compliance of the provisions of section 50 of the CRPC during the time of his arrest, in compliance with the provisions of section of the decision of the Supreme Court in the Public Broadcast of Vihan Kumar Paradi. One of the conditions for bail of the petitioner was that there was, in terms of the said order, is a fasting the bail application. The applicant shall furnish a bail bond of rupees 2 lakh with 2 local sureties, each of the like amount, one of which shall be a government employee, either central or state government, permanently serving in the state of Assam, to the satisfaction of the learned special judge in bracket NDPS competition session judge number 2, Kamrup Metro Guwahati, along with certain other conditions. It is submitted by the applicant that the said condition may be relaxed and the employee, state government or central government, permanently serving in the state of Assam be modified, submitting that his brother, who is serving in the Meghalaya Electricity Corporation Limited, be allowed to furnish the guarantee of rupees 2 lakh, furnish the bail bond of rupees 2 lakh. who is not a state government employee of the Assam, state or central government employee of the Assam, but from Meghalaya. We have seen in large number of cases that whenever there is a trial regarding the NDPS matters and an accused is from a different state, if the bailer is from other state, all are found missing during the trial. In the trial of the cases remains incomplete. In those cases pending, like in those cases remains pending for long period without trial being complete in absence of the accused persons. Considering such reasons, this court, while granting bail, observed that out of the two local sureties, one should be a government employee either state or central, permanently serving in the state of Assam, so that the accused petitioner / applicant remains present during the trial of the said case number such and such, and his absence / default, the concerned employee, state or central, serving in the state of Assam can be made answerable. The jurisdiction of the Learned Special Judge NDPS cum Additional Session Judge number 2 Kamrup Metro Guwahati will not reach Meghalaya, a different state. Considering the above, this court is not inclined this court for the reasons above and for the smooth progress of the trial of the said NDPS case number such and such, is not inclined to change the conditions incorporated in the order dated such and such, past in such and such and such. Accordingly, this application stands. Only for that purpose, nothing else.